Order of termination. What was the misconduct against him?
Application form of proposal. So it left on its own. In my memo also I have said. In my that's why sentence for the tribunal also I said that nowhere resumes the employer. They refused a very employment mix. Very relation to which
What was the appointment order? And who is the establishment here? People, ID. When was the order of termination? But when was that? When did he refuse coming to a job?
2013, the page number 91, he joined Apollo Pharma. At 8,000. 811 to may request your lordship to page number 91. Page number 9. He joined Apollo Formula. It produced the appointment order also. He only refused to come join the duty order.
When was the award passed?
Award pass was in a request. The 30th July 2019. It is at page number 14.
July 2000.
19. 30th July 2019.
When was the order passed by this court? 12.
First order?
This court order.
Interim order.
Interim order.
2019.
12. Order sheet for it. He's seeking for 17B wages from 2019 to 2024. You're seeking wages from the date of award, that is 2019 to 2024. Yes. You were employed in an establishment during the year 2019 to 2024. Notice was issued by them asking you to join these services. You did not report to duty from 2019 to 2024. You did not join. So first notice ಇದೆ ನೋಡಿ 28/11/2019 ಅವ್ರ ಮೆಮೊ ಜೊತೆ ಮೆಮೊ ಜೊತೆ ಈಗ ಅಲ್ಲ 28/11/2019 ಈಗಿದೆ ಅದೇ 28/11/19 after the award was passed. Mr. Govindraj, the first notice which was issued to you was on 28/11/2019. Then after the award was passed, you did not join because you were employed. Then, well, no under it, will it suffice that it is no? Correct. Correct. That is the show cause notice issued to him. That is 28/11/2019. Ah,
But here management stating that they have not reinstated, please go there is an award. Issue for we have not implemented the award.
see, both are at in the same footing. After the reinstatement order passed by this court, you have not called upon them to reinstate because it was a duty upon you. You wanted an order to be implemented. You wanted an order to be stayed. So if you wanted an order to be stayed, you had to comply the other portion of the order of reinstatement. You did not issue notice. You did not issue notice to him.
The issue is that after the order was passed by the tribunal, we prepared a writ petition. Then it was not posted in the usual. Then we on 15, kindly see that letter you got. 15/10/2019, he only appeared. He only appeared before the labor commissioner. What I'm trying to establish by this letter is that he was very diligent. On 15/10/2019, he applied actually. Ullekh Shri Lakshman, ಇವರ ಅರ್ಜಿ ದಿನಾಂಕ fact ಅದು. He only applied before labor commission. Then I moved this. The petition was filed much earlier to this lecture, but it was not posted. It was posted division bench ಅಲ್ಲಿ ಇಲ್ಲಿ post ಆಗ್ತಾ ಇದೆ. Then we moved this honorable court and got the order on 12/2019. We had quite a caveat also. It was very much aware of the caveat and notice the petition was served on it. Then it came before your lordship on 12/2019. So in this present reinstatement order was out and with this award it was stayed here. But that's I admit your lordship, we did not apply, we did not issue notice, but he did not approach the truth. They pass on some judgment in support of my petition, your lordship. May pass.
Time asked.
Sorry. But for labor code, first page number 1 you got. The question calling for adjudication is application of section 17B of the ID Act.
Yes.
To the date from which payment is to be directed. When the application is filed long after the institution and service of the notice of the writ petition, whether on the date of award or from the date of application. Now, I request you also to skip this paragraph. I use page number 4. 12.4. ಕೆಳಗೆ last sum. However, if the application under section 17B is filed after a long delay, as in the present case, unless the delay is satisfactorily explained, the payment cannot be from the date several years back and will be the date from the filing of the application for the following reason. Now, may I request you also to D. ಫೈವಲ್ಲಿ ಡಿ ಅಂತ ಕೆಳಗಿದೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ತೀನಿ. However, such benefit given to the workman of direction order for payment of the date anterior to the filing of the application should not be tilted against the employer by imputing to it mean that the workman can apply under section 17B at his home, at his whims and fancy and any time. The workman cannot be permitted to apply under section 17B with the writ petition matured for hearing and be held entitled to payment for several years together. So also would be inimputable to the employer. In most cases, it is impossible for the employer to verify whether the workman is employed in another establishment or not. It will be more so difficult if the employer is required to verify the employment details for say at least 10 years, as the petition here would be required to rebut the affidavit filed by the workman. If the application of section 17B is made within a reasonable time, the employer can make arrangements for payment. However, non-filing of the application by the workman can reasonably entitle the employer to believe that the employee is employed in another establishment and will not make any claim under section 17B. The employer may arrange its financial affairs accordingly. The employer who has acted on the basis of such a representation of a workman cannot, after a long period, 10 years, as in the present case, be burdened with the liability under section 17B from the back date, which is as a lump sum may represent an enormous amount and wreck the employer. Moreover, it will provide a bounty rather than the subsistence. The Supreme Court in so and so held that the principles of socialism and social justice cannot be pushed to such an extreme so as to ignore completely as to a very large interest of the employer. Thus, I hold that if there is an unusual and unexplained delay in filing the application of 17B, the court would be entitled to direct payment from the date when the affidavit was first filed by the workman stating that he is unemployed. I may notice that another single judge of so directed payment to the date of application in the absence of any reason being given for not filing the application order. To the same effect, in so laying down the delay in making an application is a factor to be taken into consideration while determining the payments to be made under section 17B. The delay in the present case is unusually long and unexplained. The workman is thus held entitled to order only with effect to the date of application that is so and so. The picture is therefore direct to pay the respondent workman an amount with effect from so and so to be calculated at the rate of lost drawn wages minimum whichever is higher. Page number 7. The last one there. Page number 7, last line. The entitlement for service from the respective dates of filing affidavits by each of them in this court in compliance.
Where are you reading? Where are you reading?
Page number 7.
Page number 7.
Last deadline ಉಂಟಲ್ಲಿ.
ಅದರಲ್ಲಿನಾ para 3 ನಾ
para 3 ಕೆಳಗಿಂದ 4 their entitlement for such wages would be from the respective dates by filing affidavits by each of them in this court in compliance of section 17 of the. Now the other one is Madras High Court. There are page 11. Madras page 11. Para 4 ಅಲ್ಲಿ may request intervention. Insofar as the second respondent is concerned, he was offered promotion in one vacancy, fell to the post of supervisor. Since he was not willing to accept the promotion, he was laid off on 88 basis. Even during the conciliation proceedings, as well as before the labor court, the writ petition management has taken a stand that the second respondent was not retraced or terminated and he can always join duty as supervisor. Since the second respondent was not retraced as per terminal section 2, so not be attracted. The dispute raised by second respondent is not at all maintained as was neither retraced nor terminated. He refused to take employment as he was gainfully employed elsewhere. Now, may I request your lordship, in my case also, I have not refused the employment, refused his employment. In the document itself, I stated your lordship. Page number 14, your lordship. No, 11 portion of 14. The second respondent has offered the post of the supervisor, which will vacant at a relevant time, but he refused to accept the offer and wanted to continue as a worker by his letter dated so and so, so and so level. Now, ಐದಲ್ಲ ಇದೆ lordship. Before the conciliation officer, after 7/4/1987 at the head, before the conciliation officer and labor court, the management has filed a reply statement offering the employment as a supervisor and denied the claim to second report that he was terminated. This was a stand we have also taken in our objections. I request the lordship to be on page 50. Para 10. As started Supra at all stages, management had offered employment in a higher court, supervisor in higher emolument. The second respondent has refused to accept the offer but expressed his option to continue as service assistant. The material available for the labor to reveal that service department was worked and all the employees except was replaced and he was laid off. When the employee refuses to take the employment offer, even without prejudice, he will not be entitled to back wages, further not taking steps to resume duty of and keeping silence with demanding employment for a long period, believed one prefer that he had abandoned his service as he claimed by the management as guiltily elsewhere. In such circumstances, cannot be construed as retrenchment and the finding of the labor court, the worker has not abandoned and not permitted to join the evidence available. Now, in various judgments from the 17 page, the para 17 also, the other courts they have mentioned.
Yes.
Page 7, sorry, page 17, with this other court. In that para 3. The award of full backway, however, totally erroneous. The labor court has not at all considered the offer of the petition employed in the written statement. In the written statement, the respondent workman is clearly instructed to receive duty could do so. In my opinion, the respondent workman will not be entitled to get the back wages in the date of the statement, as it appears that there was a response to the respondent workman that he did not report for work at all. As he reported for work after the statement was filed, he would have definitely stated so in his oral evidence, which was recorded on October 1st. The respondent workman is absolutely silent on that point. It is therefore clear the respondent workman did not accept the offer of his given by the institution. However, so may I take your lordship to my page number 48. 48, your lordship.
48.
48 by writ petition, sorry. Writ petition, your lordship. Your lordship, the memo, our first one, the labor, state labor commission from the active, and one memo is decision proprietary. Second part, if the petitioner is willing to join the next page is a type of 49, your lordship. Turn to page 40 because of the take category. If the petitioner If the petitioner is willing to join the employment as earlier, is welcome to work in the concern of respondent, and the respondent is having no objection to rejoin him and pay salary as per the present law in force. Now, may I request the lordship to page number 67, Lord. 67, Lord.
Yes.
67 is the objection filed by me before the industrial tribunal in the ID tender. May I request the lordship to page number 70 in this case. Your first.
Yes.
Para 10, your lordship, below. It is respectably submitted that the second party at no point of time has refused employment to the first party. The first party himself has left the job and has got a better job in this field, and Apollo Pharmacy as a salesman. While he was manager. And after leaving the work, the first party has joined the service in Apollo Pharmacy. In November 13, it says that before expressing his desire to the work, the first party has received appointment order from Apollo Pharmacy. Now, I request your lordship to page number 73, last paragraph, 73.
Yes.
As the second party has not refused employment is reinstated backward. So here also I repeatedly said, have no fair refused its employment. As observed in that or before the labor court, everywhere. Here in this, before this honorable court also, history model, now this is current Nandan Abhyantara
ಹೋಗ್ಲೇ ಇಲ್ಲ. You should have gone and approached. You did not approach all the while. From 2019, when the matter was listed, you were aware about the order of reinstate. Did you say in your affidavit that you approached and that was denied? No, it is silent about that also. ಮನೆಯಲ್ಲಿ ಕೂತು ಬೇಕಂತ ನಿಮ್ಗೆಲ್ಲ.
several times also. He could have complained before this court only. I am reposed, I am not entertaining him in the office.
For orders on I number 1 of 2024 tomorrow. You should have made efforts. Where is any document? Where is the any document that you or your consistent approach before the management that you want to join? Everything is silent. Yes, you can't. You take. You want to. You don't want to work. You don't want to work, but you want to get the 17B wages. Let's see tomorrow what we will pass on. For orders on IN. Who is not well? Who is not well?
That's the CO who was asked to be present before this honorable court. They're doubting dengue, it seems, my lord. So kindly have it on 30th.
Whether she can be able to come on Monday. Monday, is it possible for her to come on Monday, madam?
My lords, I think she can come at least online on Monday, my lord. This is what Somshekar sir informed to me.
Yes. Then the counsel appearing for the respondent submits that the chief operating officer was directed to be present before the court. By order dated 17/9/2024 is suffering from dengue, na?
She suspected dengue is what I've heard, my lords.
She's been suspected of dengue and she's unable to be present before the court. And seeks a date for her presence. At request, list this matter on 1st October
Much obliged.
for the presence of chief operating officer. Yes.
Much obliged.
Yes, what is this? I have 2 of 2024 for stay filed by the petitioner, motor vehicles. And what is that your colleague was mentioning? Then she mentioned something in this writ petition, in this serial number. What did you mention? For petitioner? Madam, this is serial number 14. And there is no KSRTC here in this petition. You should first look into the cost list, look at your serial number, and then your petition. What is this about?
So we can go to usually not be manufactured and very most penalty.
Blacklisting.
Yes,
You have taken notice for responding?
yes.
Now what next? When was it? Twelve, 12. What is that endorsement? Annexure? It's not produced.
Yes, this is not in essence of any of the, this is for the.
And what is that endorsement, please? Endorsement, the operative portion of the order. Stay now. What is that endorsement? But you notice issue ಮಾಡಿದ್ವಿ. Have you communicated that endorsement to him? Just a moment. When did you communicate that endorsement to the petition? When you can retain that endorsement, you should have all the acknowledgement also, right? When did you communicate? And in that endorsement, you said they have been issued notice, they have not replied, so we are issuing this order. How much is the tax amount which you have called? 20 lakhs? When was the vehicle purchased? 2012.
That's by the first owner. Petition is the second owner of the vehicle.
Right. Then from 8/12/2012, they have not paid this tax according to you. The first owner itself has not paid. Then you did not proceed against the first owner? It's not blacklisted.
Blacklisted in 2023. I purchased the vehicle in 2016.
Oh. So you would be aware about all this?
No, that's why I'm making this. I first they responded to issue the NOC to first owner and RC.
When was the NOC issued?
2016. And RC is also issued in the name of second owner, that is the petitioner in 2016.
2016.
Yes. So, responded. If at all there was anything pending as on that day, they should not have the NOC or issue the RC in my name.
Where is the NOC issued to the respondent number 2? Page number?
No, I have not produced the NOC.
Then you have to
NOC was issued to the respondent, first owner.
Correct.
RC is issued in my name.
Correct. After the issuance of NOC itself, they have sold the property to you, right?
Yes, yes.
And where is that NOC?
Copy of NOC. I don't have a copy.
You should have the copy of NOC. You should have, until you produce that NOC, issuance of NOC, how will you purchase the property? Purchase the vehicle.
Issuance of RC in my name reflects that the NOC was issued in
Which
the
is
name of
that?
first
Which is that RC? Where is the RC?
owner.
Have you produced the RC?
Yes, yes, RC is. Page 16.
16. Where does it reflect about NOC? Where does it reflect about NOC?
issuance of RC itself.
See, there are two separate authorities, right? They are separate authorities. The person who issues this
Yes,
registration
the
is,
authority who receive the NOC and the authority who receive the
and the person who issues notice to you about tax are the separate authorities, right? This is the RTA, right? Registering authority, that is registration number which has been issued to you, is a separate authority. And now who has issued notice to you?
So, notice is issued by the RTO itself. Your Honor.
RTO.
When I approach the RTO for issuance of NOC for me, petitioner company is closing its company. So to dispose of the assets, they went for the NOC. When I approach the authority to issuance of NOC in my name, they withheld the original RC. That's why even I have produced the documents to show that I have approached the authority, which is at page number 50, dated 12/12/2023, asking for them to give me the reason why my RC is withheld. Even when I approached, no response was given to me. Only when I checked it online on the Parivahan website, that's when I got to know that it is NTPT status on my that is still with a penalty of with this penalty and lifetime tax of amount 20 lakhs. Is, Your Honor, as even before the issuance of the registration for the first time, that is in the year 2012 itself, they should collect the lifetime taxes. Until and unless the lifetime tax is not collected, permanent registration should not be given.
The government will file your objections to the See, after 2000, after a long period of 2012, any time. And after the second sale, what happens then? Against whom you have to proceed? Yes, the state seeks time to file objection. Yes. At request, how much time you want to file objection? At request, a week's time. 2 weeks time is granted. List this matter immediately after the Dasra vacation in the week commencing from 14th October. Yes. 14th. Dictation. Your car is, yes, what happened? Settlement. No, we are not here to. No, if they are ready for settlement, we will not come in the way. ನೋಡಿ ನಿಮ್ಮ ಆಫೀಸ್ ನಲ್ಲಿ ಒಂದ್ ದಿವಸ ಒಬ್ರು ಬರ್ತಾರೆ, ಇನ್ನೊಂದ್ ದಿವಸ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ. Then again one third person comes. At least you maintain some decorum. You maintain some decorum. At least one counsel to appear only on that matter, and the other counsel comes. Yeah. Okay. That should have been done. Is there any possibility? ಇನ್ನು ಮಾತಾಡ್ಲಿಲ್ವಾ ನೀವು? At your request, at your request, when the matter was listed for dictation, at your request, since you said that we would try for some settlement, when the matter was listed on Friday, it was urgent to today. Now, you should have done something by the period, by that period.
I request Bharat to act on Thursday or dictate finally. With the time you will approach the claim.
Not Thursday. See, if at all, you should have done this all by Friday, right? Yet give some madli landra. What can we do, Mr. Mr. What is your name? Narayan Rao. The matter was listed for dictation on hearing all the parties. And at your request, since you said that an endeavor would be made for settling, this court adjourned the matter for today. You should have made these efforts in the interregnum, right? Having not done so, do you expect this court to adjourn this matter all the time? Ola, do you want this court to adjourn the matter? You're coming in the way of a dictating orders. Just a moment, Mr. Chairman. Why did you not do it on the occasion when you were granted time? ಆಯ್ತಲ್ಲ told ಅಂದ್ರೆ ಮುಗೀತು. Again, why you want to ಅಲ್ಲ ಅಲ್ಲ ಕುತ್ಕೊಂಡು ಮಾತಾಡ್ಬೇಕಾದ್ರೆ ನೀವು ರಜಾ ಇದ್ದಾಗ ಮಾತಾಡ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು. Now you said the same thing. You have not even done any efforts. You get your senior. We will not pass over. Until there is some positiveness on your part, we are not going to adjourn this. If there is no so let your senior come. Let your ನೀವು ಅಷ್ಟು ಮಾಡ್ಬೇಕಲ್ಲ. When an adjournment is sought on the pretext of an settlement, you should have done some efforts. What is the efforts? What is the efforts you have done? Have you communicated to the appellant here? Then how can we believe the words of yours? If you have not made any efforts, how is the court going to think that there is a settlement? ನೀವು ನಿಮ್ ಕಡೆ ಸೆಟಲ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡ್ರೆ ಸೆಟಲ್ ಆಗತ್ತಾ? Until you put it to the other side. Yes. Or by 2:30, otherwise for dictation. No, 2:30. Mr. Narayan Rao. ಇಲ್ಲ. ಬುಧವಾರ ಇಲ್ಲ. Pass over. We want your senior to come here. Ask your senior to come here. This Mr. Prakash, what happened to the settlement? Yes. Well, let them file an undertaking pursuant to the compromise which you enter.
Not so cooperative. He sent a letter, using that letter, with the agreement for the fees, not interested in what is the property. But he is a party, he is a fourth appellant. If I file joint memo, I need to get his. Possible. Even I tried to get our affidavit. That also.
What is the affidavit you have written?
I got a letter through email. Photos. I request the base of this undertaking. I may be granted and that will be.
We mentioned the inability of the appellant number 4. Where have you mentioned? It will take this affidavit. Now, this would be a binding upon them. They have also produced the email to that effect, which is sent by appellant number 4. So that would be a binding upon them. What is that? Yes. They have given an undertaking, then you are entitled for to take action against them. If you mention something about it, it means we are giving a legalization to the to stay in the premises even after the. See, you cannot go now. They are giving an affidavit showing that they will vacate. So you have to assume that they will vacate. You cannot say in the event that they do not vacate. What would be the damage? It's been you are giving a right to them to continue. So that is then you are entitled for the damages. You are entitled for the amount which they stay in spite of not vacating the premises. If they stay in the premises, you are entitled for that amount. We need not mention all that. This will create again a separate cost. This- The appellants files memo along with the undertaking affidavit filed by the sixth appellant as special power of attorney holder of appellants 1, 2, 3, and 5. And as per the authorization given by the fourth appellant, the said memo reads as under. Undertaking affidavit is filed by appellant number 6, Prakash, son of late Channabasappa, as a special power of attorney holder of appellants 1, 2, 3, and 5, who are his mother, who appellant number 1, 2, 3, and 5, who are his mother, brothers, and sisters. And also on the authorization given by the appellant number 4 by way of a letter dated 12/9/2024 to swear to this affidavit. The who are present before the court, appellant number 1, appellant number 6. Yes, at para number 6 of the affidavit, it is mentioned that the fourth appellant by name Deepu is out of country on employment and he is not available. And the fourth appellant has sent a letter through email on 21/9/2024, agreeing to vacate and hand over the suit schedule premises as agreed by the other appellants. And he has no objection to file an undertaking. The copy of the email dated 21/9/2024 is produced along with the affidavit. The affidavit of appellant number 6 is taken on record. Which reads as under from para number 1 to 14. In light of the undertaking by the appellants, the para 6 appellant number 4 the appellants have hereby undertake to vacate and hand over the shoot schedule premises to the first respondent without driving him to approach the executing court and without raising any objections on or before 28 February 2026, and to pay rupees 5,000 per month in respect of the suit schedule premises towards use and occupation from 1/9/2024 up to 28/2/2026 without committing any default. And we shall pay the same on the next succeeding month, that is on before 5th of that month. The affidavit reads as under. In terms of the affidavit, the second appeal stands disposed of, granting time to the appellants to vacate the suit schedule premises on or before 28/2/2026 without driving the respondent number 1 to approach the executing court and to pay monthly rent of rupees 5,000 from 1/9/2024 to 28/2/2026 without default. In the event the undertaking given by the appellants or any of the condition undertaken in the affidavit are violated, the respondent number one is at liberty to seek for possession of the suit scheduled properties in accordance. Yes. Let them be happy at least for at least 2 years. Hinga ತಗೊಳ್ಳಿ. Take the signature of appellant number 6 and the respondent are present before the court. Duly and their acknowledgement and their presence is acknowledged by their respective counsels. Signatures ತಗೊಳ್ಳಿ. Yes. Yes.
The reminder of the fact that so that I can argue the sequence where you know.
Just narrate some facts of the case. So that you know what is.
Dependent, creative is claiming it as a joint family property. There are 9 items, you know. Whether is about 8 acres. About at an undisputed point in time, about the year 1961. But one of the items, the major item, because there was a sale by claiming father. About 36 years of that sale, total before the lordship. Speaking partition, about 9 items of alignment. Not really plain, except a self-serving statement that it's a joint family property. They are not pleaded anything, nor they have produced any document except exhibit video. It is one of the RTCs regarding one small item. Our case was that there was a oral partition about 5 decades back when I have filed a defense statement in the year 2005. So that means there was a oral partition in the year 1955, around 55. Lord, as per the oral partition, item number 1, item number 2, item number 6 to 9 fell into the share of second, that is given and 1 to 5's father. On the other hand, my lord, item number 9, that is 84/2, within 1.36 acres, is attached. And other 2 items, that is respectively 87/7 and 98/1, fell into the share of his father, Mariam.
Yes.
Independently, 2 of the items.
One item was sold in the year 1961. The other item was sold as per agreement C3.
So
Not,
what fell to the share of plaintiff's father? Plaintiff is survey number 84/7.
it is father, yes, yes. Father.
Yeah. So 84/7, 84/2, and 98/1. So these are the three properties which fell to the share of.
He had alienated all the two of the items.
That is 84/7.
Three of them, all he sold. He sold everything.
All the three.
Yeah.
Yeah.
The document before the lordship only about two of the sales.
Yeah.
But he sold everything.
He sold item number 2, item number 9 as well.
98/1, 84/2, 87/7.
He sold 84/2 also.
84/7, 84, yes, yes, yes.
He
That's
sold
what
that.
he sold to Kalaya.
Kallaya.
Yes.
Yes, Kallaya.
One of
Correct.
the fact remains that though she claims at this distance, there's a joint family property. She herself admitted that she left the family in the year 1970, soon after the death of her father, who was in Bangalore. He settled in Bangalore. He was working in Minerva Mills, and he died in the year 1966.
Yeah.
But these are the facts. But in this actual scenario, the substantial question of law, I am requesting your lordship.
Now, what was the substantial question of law framed by this court?
Not that something question of law
Whether the courts below are justified in recording a finding that defendants 1 to 5 have failed to prove oral partition in respect of the properties described at item
Yes,
number
yes.
1, 2, 6, 7, and 8 in the
Yes,
schedule.
yes. Even
In
that,
light of the overwhelming evidence.
exactly. Even that, my lord, requires particular notification. In the sense, my lord, we have produced several other documents as well regarding oral partition. My lord, now presently, my lord, I am seeking your lordship to raise the following substantial question of law. One is, my lord, whether the courts below are justified in decreeing the suit, holding that two properties are joint family properties in the absence of any pleading, material evidence produced by the plaintiff, the opponent to establish the existence of joint family and the two properties are joint family properties.
Yes.
Number one now. Number two, whether the courts below are justified in recording a finding that given of 1 to 5 are going to do the oral partition. Item 1, 2, 6 to 9. In the light of overwhelming evidence, as per exhibit P3, P4, P5, P6, P2, and P3, but now I am including 7 documents already marked by them.
So this substantial question of law which has been framed on 14/9/2023 is elaborated in substantial question number 2 framed by you now.
Yes. These these subject question of law are interrelated. If one is going to other will go. Secondly, the third is not whether the court will are justified in holding that the properties mentioned in item number 9, that is item number 82/2, is scheduled to the claim is not a self-record property of the defendant 1 to 5, having regard to the recitals and intents of the parties as discernible from activity by the police, whereas plaintiff's father has sold this property to vendor his father.
Yes.
This is, my lord, after this, if
Because
this
your contention is after the sale by the plaintiff's father to your vendor, you have purchased from the vendor from your individual.
Perceiving that, the law is holding that oral partition proved in my favor. Till then, it's remembered because 84/2 fell into his share. Even oral partition proved. I'm not getting it. Because as per the oral partition, it is his property.
And he has already sold the property.
That is another aspect. But first thing is 61. Lord, even if the oral partition is proved, then Lord, 84 is a separate entity. Because it fell into his share. So that this question is important. Next, my lord, whether judgment and decree of the court will initiate for reconstruction of the character and effect of the material document at 55 and 6, drawing inferences from the proved facts and for evidence shifting the burden of difference. However, why this is relevant? Because the courts have held that a particular deed of exhibit P1, P6 has reconveyance conditional sale, mortgage by conditional sale, not as the mortgage by condition to repurchase. My My case is that Malord is a condition to repurchase. Is a document, prima facie shows that. So they have misconstrued the document. When the courts have misconstrued the document regarding the character and effect, Malord, it is a question of law, the law should prevail. Then Malord, just this Malord, whether these two questions Malord may not arise at this stage, but has to be framed Malord, because considering that exhibit 5, D5 is a terminal date, that is exhibit P6 Malord. But considering that is a reconvenience deed, Lord, it is considered that is a conditional sale, not like a conditional sale. Whether the court will not justified in decree the suit when the father of defendant want to had subrogated the rights, right and interest of the parties in the absence of any evidence persuaded. Taken to establish that ambiguities from which the said properties were redeemed. Not known if subrogation will come in the later stage. Then, Lord, consider suit property is a joint property. Because court will just holding that, maybe this is 1% share. She is not even entitled to share because of the latest judgment of the Supreme Court. They have share. Or Lord, I will come to that one. It will not be, Lord, I will be able to convince this poor question of law, my Lord, so that if I am not able to convince that, these two things will follow.
We will only frame 1 to 4. 1 to 4. We'll frame the additional substantive question.
Frame model. Not for frame model, there is no harm.
There are two questions now. Exhibit P5 and P6 are the documents which show that the plaintiff's father has sold the property or mortgaged the property. In any event, if it is mortgage or sale, mortgage, did he pay that amount? Did he repay that amount? Then if you have repaid the amount and in light of a partition and in light of the item number 9 having fallen to his share, he has his right has been gone in light of the.
If your lordship were to hold that it is an oral partition true, if the oral partition is full, or if he has sold the property, kindly visualize the situation, Lord. Lord, there is a registered deed. They have, my Lord, exhibited it. They have produced it, not we. It is their document. Admittedly, it's a registered document, standing for more than 30, 40 years. Does it not bind the plaintiff? And my Lord, if that is so, Section 3 of the Transfer of Property Act will come into play. The registered document, presumption is knowledge is there. And then, my Lord, once again, my Lord, limitation. My Lord, Article 58 will apply. So, my Lord, if she is, whether she was a minor, whether there is a different issue. Even if she is a minor, Article 60 will prevail. There is once again limited. But at this stage, what I am submitting is, without, my Lord, there being a prayer, assuming that, my Lord, she is right only, without there being a prayer or declaration of that particular document, near partition at this stage, my Lord.
That is settled. They did not seek for declaration that the sale deed is not a binding or the sale deed is null and void. They just have to file a suit for partition.
If the document is there.
No, even if it is there. If she's entitled, she's entitled. No, she's not. Ganpati judgment.
This is the position, my Lord. This says produced document.
And we, as a party to one of the judgment by the division bench.
About her knowledge.
Yes.
Lord, then your lordship is that comes to the issue whether the document is sale or a mortgage. Even on the other hand, my Lord, if your lordship is holding that, my Lord, the oral partition is not good, and the document is a mortgage deed, still, my Lord, question is, in what capacity is my Lord he has done that? It's a co-owner. If the oral partition is not there, he was a co-owner. He was a co-owner. The person who is Kalaya will step into his shoes under section 44 of the PPI. So he will become a co-owner. Then, my Lord, I have redeemed or whatever it is, my Lord, from him. So my submission is that I will be entitled to protection 92 of the PPI.
You have to first establish the oral partition.
Yes, that's what I am saying.
Correct. Once we establish that there is an oral partition, then it becomes your individual property on purchase. That's correct.
But let me not go by sequence wise. First of all, whether there is a joint family property or whether there is a oral partition. Then second question is not what is the nature of the document. That I will come to that. If that is so, then other things are not material or not. Third aspect, whether a partition is held to be not true or not, then I will come to in my reply. No, no. Addressing this first and two, second issue, certain question of law.
During the course of our argument, the court has framed the following substantial questions of law. Whether the courts below were just additional substantial, whether the courts below were justified in declaring the suit, holding that the suit properties are the joint family properties. In the absence of any pleadings by the plaintiff to establish the existence of joint family and the suit properties are the joint family properties. Next, whether the courts below were justified in recording a finding that defendants 1 to 5 have failed to prove the oral partition in respect of the properties described at item number 1 to 6 to 9 in the suit schedule in light of the evidence as per exhibit P3 to 6 and D2 and D7. D3. Whether the courts below were justified in holding that item number 9 in the suit schedule. And the courts below were justified in holding the defendants 1 to 4, 1 to 5 failed to prove that item number 9 is the self-acquired property of defendants 1 to 5 in light of the documents marked at exhibit P5 and 6. Whether the courts below were justified in holding that the plaintiff is entitled for 1/4 share in the suit schedule properties. Yes.
But the idea is to address the first two issues.
Yes.
Not the basic aspect is that.
No. Issue number correct 1 and 2 additional substantial question of law. No, 1 and 2 and substantial question of law number 1
Interrelated.
and substantial question of law number 1, which was framed on 2023. So this also has to be taken together.
Document together first.
Other jotene, we have to take both this together. Substantial question of law number 1 and 2 and the substantial question of law number 1. Are they same agud? So we need not go on again.
But I am not on the issue of burden of proof here, because my lord, that may not be relevant, but still, the lordship said that there is no presumption as to joint family property at all. There may be a presumption as to joint family asset,
Yes.
not about joint family property.
Yes.
Lord, the lordship really looking to the state.
Paper book is dispensed with. Paper book is.
Paragraph 2. Plaintiff submit that plaintiff want to are the daughters or my who late period. This is member of my family. This is of Maria's brother Chikana. And Bajja, their father.
Yes.
Bajja had sons namely Mariappa and Chikana. This is the only, and Bajja had two daughters. This is the only statement, what I am referring to as self-evident. Nothing else in the claim. And my lord, the items 1 to 9, that is also lordship D. And genealogy 3, lordship agreed table is at 77. But Mariappa has submitted already. Mariappa, why it is already oral party? It's not a case where we are saying that there was an oral party. And subsequently, we are put into a paper, into a document, registered. And then it has to be proved. It's not a case. We are relying upon the oral partition which was held long back ago, that is about 55 years back, on the basis of public documents to show that these documents, this partition was acted upon. It's acted upon.
Just one.
These public documents, they're all the documents, they're all produced by the plaintiff herself. But this document shows, Lord, plaintiff's father had independently dealt with the property and separately dealt with the property and had alienated the property in own capacity, right from 1955. Lord, one of the document is Lord actually P6, another document is Lord actually T3.
Yes.
But actually P6 is Lord the sale is dated 11/10/1961. Thereof, my lord, item number 9, which had fallen into his share. That is very important, which had fallen into his share was alienated to Uncle I.
Yes.
Lord, then other document is, my lord, exhibit D3. Because, my lord, it is regarding 98/1. Your lordship say where what are the properties fell into share of Maria?
Yes, yes.
That is 3. The other item, my lord, is 98/1, which is measuring about 32 buntas, my lord. He had alienated as per exhibit D3.
What was the recitals in the sale lead?
But example is more. Because
Yes.
I would like to finish this asset.
The only thing we want to know, did he say it is as a karta of the family, he is selling the property?
He is independent saying, my karta, my property.
And selling.
I will come to that.
This is not.
Lord, this is one aspect of the matter that we have dealt with exclusively. Whatever had fallen into share. Number 2, my lord. Defend number 8, who is the son of Chikkatayappa, who is the son of Chikatayamma. Chikatayamma is none other than the sister of the plaintiff, daughter of Mariappa. That's what I used to do it's needed, my lord, the
Genealogy.
genealogy admitted.
Defendant number 8 is who? Son of
Son of Chikatayamma.
Chikkatayamma.
Yes.
Defendant number 8.
Yes, defendant number Chikatayamma is defendant number 6.
Correct.
But whereas Hanumanta, defendant number 8, who is representing all of them, he filed return statement. He had filed return statement. Kindly take into the return statement by Lord the defendant. That may be relevant because it's relevant to look into now, Lord. Can you look at the return statement by defendant number 2? That is Naranappa. Lord, paragraph 5 and 6. 5A is relevant.
Written statement of defendant number 2.
That is Naranappa.
Yes.
Paragraph 5.
Defendant number 2 is the branch of
Because,
Chikkanna.
yeah,
What is
to
your
find
branch?
seal.
Your branch. Yes.
The defendants became the absolute owners in possession, cultivation with respect to scheduled property after the death of their father Vikramana. It is admitted that Bajja alias Bajjaya had 2 sons and 2 daughters. Your daughters are not wed parties. The partition between the father and the plaintiff and defendant father taken place about 5 decades ago itself. Lord, really look the date on return statement, that is 6/10/2005.
Yes.
Page number, next page.
Yes.
That means 1950s. Lord, kindly note this. The properties fallen to the share of the plaintiff's father are 7 number 84/7, measuring 1.2 gunters, 7 number 8/4, that is number 9, measuring 1 acre 36 gunters, 98/1, measuring 32 gunters. This specifically pleaded. It is specifically pleaded here.
Yes.
All the properties fallen to the share of the plaintiff father, Mariappa, were alienated by him. This is not denied. And it is proved by documents. After the partition, the said Mariappa went to Bangalore city and settled there with a white collar job at Mirabolis and died while he was a service. This is there to 1966 month, admittedly. It has come in the evidence. The manner of plaintiff was arranged by his father, Mariappa. Some of the settled properties were continued in the name. This is also told, where scheduled properties were continued in the name of defendant's grandfather, taking advantage of this thing for making illegal efforts. Now, only one at that exhibit P2. That's what we are referring to. Exhibit P2 is, that is 9, exhibit P2 is not the RTC, pertaining into not the 99/27, that is intent interest.
Yes.
This had the one artist not in the name of Maria Bajja. That also was stated clearly.
Yes.
Yes, my lord, paragraph 6. The father of the defendant was a continuous position of the continuous as of the property, 1 and 2, that is followed to share law. Which are acquired by partition, and item number 6 and 8, the house properties are also acquired under the family partition. And item number 9 is self-acquired property. It is purchased by his father under the registered deed on Kallaya. The scheduled properties, item number 1, 3, 4, and 5 are not the properties of the family.
Yes.
So that here we are referring to item number 9, self-acquired, because it is not self-acquired in the sense of purchased from outside the family. It is because, my lord, a property which is told by Mariappa after partition. Okay. That is why we have contended self-echoproper. In that sense, it is self-echoproper.
Correct, correct.
Yes. No, my lord. That's why he said we are not, it's not the joint family property at all. The other two have filed return statement, which may not be relevant, but when you get to the return statement by defendant number 3,
Who is defendant number 3?
one of the sons of Tikaya.
So they have taken similar contention.
But paragraph 1 is relevant, saying that include this item 84/2 was included after the evidence during very latest evidence in that. Now, kindly come to the return statement by D1. Now, table number 8.
Defendant number 8 is the son of Chikkatayamma.
Chikkatayamma. He is Hanumanta. But he is representing all of them.
He is the one.
Yes.
Plaintiff is also supporting the plaintiff. He is supporting the plaintiff.
How is supporting?
Where is defendant number 8's return
That
statement?
statement you lot of the last time also. Table number 8.
Yes.
We are read now. The suit filed by the plaintiff is frivolous. Our own system, vexatious. Just to bargain, benefit, unjust benefit in the ulterior motive. Paragraph 2
His plaintiff's sister's son.
Plaintiff sister son, defendant number 6 is the sister, defendant number 8 is the person who filed the return statement.
Yes.
Where is not paragraph 2.
Yes.
The defendant number 2 categorically denies all the government made in the play and all unperfect created to just to prefer the truth. They're all untenable grounds in order to grab the property. It is further submitted. The plaintiffs have no not from the same hand for the party. The plaintiff's husband is a chronic litigant with an habit of filing cases after case against innocent people. And this case is initiated to his wife, mother-in-law, thus to harass, again, unjust benefit. This is in the context of what? She was married long back. And she settled Kamakshi Pandya and well settled. Paragraph 4. The genealogical tree described as is not correct.
That is not very relevant. She has not disclosed any of her other sisters
Not
and
disclose anybody. Property could ಯಾರಾದ್ರೂ ಸೇರಿಸ್ತೀವಿ. ಅದೆಲ್ಲ ಇದೆ ಅದು ರಿಲೆವೆಂಟ್ ಆಗುತ್ತೆ ಲಾಸ್ಟ್ about 1/4 year ಎಂಟೈಟಲ್ ಅಂತ ಹೇಳಿದ್ರೆ
whether that is an intersay between them. A branch of Mariappa children. Mariappa sisters is one thing. Now whether she has left her sisters Parvatam. Now that would be an internal dispute. If Mariappa is getting one share in that branch, then the question of internal.
I am saying, would tell that she is entered 1/4 specifically.
Now 1/4 ಅಂದ್ರೆ in light of Mariappa. 1/4 ಅವ್ರಿಗೆ ಬೇಕಂದ್ರೆ ಅವ್ರವ್ರನಾಗೆ ಮಾಡ್ಕೋತಾರೆ. In the event that is this later. In the event she gets 1/4 share.
Then you can paragraph 5.
Yes.
The defendant became the absolute owners in possession, cultivation, respect scheduled properties after the death of their father. It is admitted that Bajaya alias Bajaya had 2 sons and 2 daughters. Partition between the father of the plaintiff and defendant's father had taken place about 5 decades ago itself. After this partition, the Mariappa went to Bangalore. So this aspect is clear, my lord. Even the defendants are admitting there was oral partition.
And they are from that first wife's children only. First wife's children.
Exactly.
Yes.
And paragraph 6 and after 7, 8 lines. When there was a joint family property, there was a partition. Question of partition does not arise at all because there is oral partition. This is the categorical interstatement law. This is not disputed. Whatever it is called, it is admitted. So this is the representation. Lord, this is to the fact that Lord admission by one of the defendants. It has much bearing.
Yes.
Lord, coming to the documents we have produced, Lord. Lord, what I am saying, hitherto, my Lord, if there was no partition, there was no occasion for him to sell the property ignorantly, and there was no occasion for him to admit, they themselves admitted. And the suit was filed, my Lord, after more than 4 years. Of these documents, you have the public document. That will be my Lord.
Yes.
This is the house tax assessment register. Lord, there are 3 house sites, my Lord, in the name of, in the form of 6, 7, 8. That is small in the extent, my Lord. 45, 42, 10, 18, 20, 20. These are these 3 house sites which fell into the share of Chikaya.
Fell to the share of Chikkaya.
Yes.
Yes.
So now can you see the register which is of 1998.
1998.
These are first dependent. Mutta.
Yes.
These are in the name of first dependent. That is Muttamal, not even his father.
Yes.
Coming to the next document is Exhibit P4. For P4, let me tell you. Exhibit P4. This is in the name of Chikkadoddamma. Chikkadoddamma is none other than the wife of Chikkaya, Chikkana, father of the defendant.
Okay.
84/2, that is regarding item number 9,
Yeah.
which had fallen to Maria as per the oral part, not the Chikkana.
What's the name of whom? Tukkadoddamma.
Chikkana is wife of Chikkana. Even Chikkana's name is also there, but okay. Before, this is item number 9.
After when was this entry?
It's of course 2002, but I have produced additional document, so that 69 allee agide. The doc application for additional document, my lord.
Yeah.
69 allee agide. Kindly come to my lord exhibit P5. This is the sale deed.
Exhibit P5.
Yes, P5.
Yes.
But better to look at one exhibit P6 first of all, because subsequent document exhibit P5. P6 may be seen. P6 may be seen first. Because this is subsequent document. P5 is subsequent document.
So P6 first.
P6 is first.
Dated.
Dated 11/10/61.
Yes.
Now, where my lord Mariappa had sold the property to Tikkakalaya. That is 84/2, measuring 1.36 kuntas. That means almost 2 acres.
You're stressing only on this item number 9.
Not only that, but it is, but even if, that's what I said, even if the oral part is yet to be proved,
And she's
still,
not
my
aware.
lord, this is other aspect. Because it fell into this share.
Property stands.
Yes, not kindly. Once again, you start coming to this document later, I will give it the recite also.
This is the first sale deed. First
Yeah.
sale deed. By
1961, 11/10/1961,
By
exhibit
Mariappa.
P6.
Mariappa.
Yes,
So what is his name? Kallaya.
Kallaya, Chikka Kallaya, also called Kuri Kallaya.
Yes.
But this is the document. I will come to the recital later because
You
there
have
is
read it on the other occasion. Property stands in the name of Mariappa and is in his possession at the Yakara.
tell.
Yes, next one.
Yes, I'll come to that later. Now come to my lord, kindly come back, 55. This is my lord, where Chikkanna purchased from Chikka Kallaya. This is dated 3/7/67.
Any document to show if it has been held to be a mortgage, she has paid, they have paid that amount. Anna, have they paid that amount? Not you. The first, if it is taken as a mortgage, that the deed of 1961 in favor of Chikka Kallaya, then whether he has repaid that amount, Mariappa has not paid that. No document.
For 2 years.
Even if you take it as a mortgage.
Even if your lord is taking his mortgage, if it is expired, then my lord,
He has a right to sell the property.
after expired, what will happen? That is the thing. No, my lord, kindly see another 2 documents which is produced by us. That is exhibit T2 and T3.
What are they?
It is a very vital document, mutation.
Mutation entry pursuant to?
Lord, your lordship have seen exhibit T3. The T4, that is the RTC for Lord H4/2. Lord, trying to look at the mutation now. Exhibit D, Lord 2.
Yes.
Lord, in the name of Chikka Doddamma, there was mutation in the year, Lord, around 1970, 70 and 80. Because it says about 10 years of her husband's death means, Lord, around 70, 1980. It's a mutation.
Yes.
But it says, Lord, I'll read. ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಹುಬ್ಬಳ್ಳಿ ಗ್ರಾಮದ 84 ಜಮೀನು 1 ಹೆಕ್ಟೇರ್ ಎಂಬುವರ ಗದ್ದಲಿರುವ ಖಾತೆ ತೆರವಾಗಿರುತ್ತದೆ. ಸುಮಾರು 12 ವರ್ಷದಿಂದ ಉರಿಯಪ್ಪ ಕೆಟ್ಟಿರೋದು ಮುಟ್ಟಿರುತ್ತದೆ. ಆದರೆ so there was a mutation.
Yes.
Then exhibit D3 is another sale deed, right? Mariappa. Not sale deed, but that I will not talk on that much.
In respect of which is the survey number?
That is Lord 98/1. Eleven 32 Buddhas.
Mariappa. The property which fell to his share. The property which fell to his share.
Allegedly, the rest of all part.
Yes. Yes.
Lord, have tried my Lord application. The health will be considered and then finally.
So you want to contend that by way of additional documents that after the sale in your name, in your favor, 1967, the mutation entry has been effected.
Yes.
Huh? Mutation and the revenue records. Husband death. What is the additional document?
Can you get the additional document? Our lordship is not allowed yet now till this stage will be relevant to look at
Yes,
this. Additional document.
Yes.
One minute of is no, this has much bearing. This will keep the issue in fact. No, this is about RTC of 1969 and 70. Regarding 99 bar 10,
In whose favor it was?
to my share. To my share. I'm going to try to look at column 9, Tikana.
No.
No, Lord.
Yes.
But I request your Lord retracting to my Lord exhibit B to him. Exhibit B to because this exhibit related to exhibit B only, B2 only.
But P2 is the name of chicken, that is Mariappa and Bajappa,
Yes, ma'am.
entered in
The
99.
trial court, my Lord, entirely depend upon this documents of the later stage. When you look at the document exhibit B2. God, this is of the year 96-97.
Yes.
No, 66, 69 only, 70 only, it is in the name of the
The very property, no, that is
very
no, 99 bar 10 antara idu. What is 99 bar 27?
Next one is no, this is also 99 bar 10. 99 bar
To
10.
show that in the oral partition, this property fell to your share.
Yes.
One.
Yes.
Then next one.
Next one is show that it fell into my share. Yeah. Next one is now the very same RTC, the very same serial number of 70 to 74. Now come to my Lord, another document, page number 14. 68-69 RTC.
Good. Good. Yes. Page.
Block 40, 1-4. 68-69, the year of RTC. Serial number 84 bar 2, that is the one sold by Mariappa. Item number 9. It's in my name. The cultivator's column, my name is Paul. Big number 18 is continuation of the same number card is the year 78-78. Continue. Then, my Lord, finally come to what earlier I said, not 25. This is exactly what I was referring 29-27. Serial number 29-27. What you just referred to now. 89-27. This is measuring 10 gundas. RTC of the year 68-69 is in money. It had fallen into the share of chicken. And my lord, they have put exhibit B2 of the year 96-97, showing it in the name of Mariappa.
Exhibit P2 is of the year 90?
96-97.
96.
97. Now this is of the year relevant year 1969-70. Lord, only based on that, the trial courts have not decreed the suit. Only based on exhibit P2, accept that. And I'm pressing on this because
Yes.
Lord, I'm pressing on this because to point out the concurrent error by the court below. Or concurrent finding as such. The concurrent error, but they have only read out exhibit P2. I read that. Only exhibit P2, saying that it is the name of Maria, how it is joint family, how it is not a joint family. Come on, to contradict exhibit B, this is a document, my lord, of 1968, a public document, it shows that, my lord, it's the name of chicken. This is my share. My lord, kindly come to page number 33, where appears to be don't taken.
Taken by you.
Yes. Regarding 99/10, 99/27, those which are my property. Then my father, it is all this. The year 75.
Yes.
We have borrowed. There is some transaction show that borrowed, it was mortgage, it was the loan was taken.
Yes.
So last 36. This we are willing to show my lord. After the partition, all of them have constructed the same houses. Their children, not their grandchildren, are staying, selling these properties.
In which property is this pertaining
It is
to?
84/2.
The respective portions.
Yes. 8/9, item number 9.
Item number 9.
9. ಆಮೇಲೆ ಎಲ್ಲದರಲ್ಲೂ ಇದ್ದಾರೆ ಪೆಟ್ರೋಲ್ ತುಂಬಾ ಈಗೇನಾಗಿದೆ ದಿಸ್ ಇಸ್ ಥರ್ಡ್ ಫೋರ್ತ್ ಜನರೇಷನ್
Item number 9 measures how much?
1.36 that means 4 guntas less than 2 acres.
Yes.
Why I am putting this knowledge? She is third generation. She filed a suit later. Normal children of them are property. This is a stage Lord at this point in time. But this is the document knowledge which are relevant. Not I am not putting any document other than public document. These are all the documents because the person who is the Buddha is the person who doesn't his senses are not proper. He doesn't have eyesight and all that. So that they couldn't take particular document is that point in time. So that their children now grown up, they have taken it.
Yes.
So that now these documents which has much bearing on the merit of the matter, to adjudicate the case effectively and completely finally Lord, these documents are required. there is no much objection for this additional document except saying that they leave it for the fact of they cannot dispute also. Only thing is at this stage can I produce it? No, it's permissible in law. Article 41 Rule 27 not permits it. The circumstance the laws where I don't want to elaborate on.
Yes.
So my request is this document, additional document may be considered and it may be allowed. In the light of these documents,
Establish that there is a oral partition.
oral partition which had taken place not in the year 1955
And that has been effective, parties are
has
acting.
been acted upon. But oral partition is a case where I'm not saying sometimes what will happen there will be unregistered documents, say that they had partition from long back and put into paper. That's not the case here. So then what the trial courts are holding is saying, they're saying you're not proved it, you're not proved it. But I have proved it, it's acted upon. Even Vinay Sharma's case also, it says, my lord, clearly, it is permissible in exceptional circumstances, the public documents are available. So I have produced a key number of documents to show that, my lord. Not only, my lord, it is ambiguous. Clearly, there is bifurcation. Clear bifurcation between two families. And, my lord, the revenue documents, not only revenue documents, other documents show that they are also with the party. On the other hand, my lord, the reverse side of it, she has not produced even a unit of document except actually P2, that is of 1996, regarding 99.27, which is the property of Chikarna. But I have produced documents for that. Even in the year 67, 68, 69, 70s, 80s, this RTC stood in my name, so that has no bearing at all. And people could not be fed up. Lord, in this juncture, my Lord, kindly look into one or two judgments regarding joint family, my Lord. These are group of joint families. My Lord. But in this first case, my Lord, it's father and father versus his purchaser. The facts of this paragraph 2 a little bit. But father had alienated his property, and my lord, which is his share, and wife and children have filed a suit, saying that it is not his property. Paragraph 7.
Yes.
Question to be determined in the present case as to who is required to prove nature of property, whether it is joint family property or self-effective property. With that language. So, can you look at paragraph 11? Judgment was cited, it was reiterated. What is in the observation stage?
Apala Swami is the first case. Apala Swami is the first case regarding this case.
Palaswami is the first case, Lord. I have the judgment, Lord, but that is cited in paragraph 9. Lord.
What is it?
Paragraph 9. When you get paragraph 9,
Okay.
only up to 15 lines.
A position
Group
of
of
law is
petitions-
laid down in this Apala Swami judgment.
Here case, Lord, they are not even going nucleus of the family at the hands of Tikana to purchase. There's nothing about it. Either they have to say, my Lord, they are in joint family.
Yes.
Their evidence is, my Lord, I will show to the evidence, say that I am not in family. I was not in the family at all. I left the family long back as in the year 1969. So joint family itself is not there. presuming that joint family is there, my lord.
In this, she has failed to discharge her burden.
Yes. Lord, can you look at paragraph 17? What I'm saying, my lord, joint family is going to find property and so on, nucleus is nothing is there except one sentence and executive. Can you look at paragraph 17, my lord? You know, the above discussion, the respondent had failed to discharge the initial burden of establishing that there was a nucleus in the form of any income whatsoever from item of property, and no other nucleus to state. Burden remained on the respondent to establish item of property or joint of property. In this view, fact that first escalate was not let any evidence that the number of in view, in this view, in fact, the first appellant has not led any evidence to establish a separate income is of no consequence, so far as the claim of the respondent is concerned. But what I am highlighting here is more property is purchased, which is the share of Mariappa sold and I have purchased. Sold and I have purchased.
In fact, item number 9,
Yes.
purchased by defendant number 1, defendant number, father of, purchased by father of defendant number 1,
Yes.
was out of any joint family nucleus or whether there was any joint,
Yes.
according to the plaintiff.
Yes. According to oral partition.
Then this would be at least
84 will be still in his share.
Yes.
Then not he sold the property.
you purchased the property.
I have purchased the
Your father
property.
purchased it.
Unless, my lord, they have to challenge the document. My contest is that.
That we will
That
not.
okay.
That is settled.
Sorry. That is one aspect. Still, my lord. They have to say that from the family nucleus he has purchased it so that either a market.
That is what he has to first establish that the suit property was the joint family property.
Yes.
And secondly, in the event the defendant's father has purchased the property, he has to prove, the plaintiff has to prove that the purchase of defendant's number 1's father is from the nucleus of the family.
The fact the property was fetching income. That should be there.
Yes.
My lord, what is the proposition here is that, my lord, if who has to prove it? My lord,
It is for the plaintiff. Burden is on them.
they have done that.
Burden is on them.
Yes. If I am not leading any evidence to that effect, it's of no consequence because that is only corollary to that
Yes.
failure. Then, my lord, paragraph 18. The legal principle, therefore, is that there is no presumption of a property being joint family property only on the existence of a joint in the family.
Yes.
But here there is no in the family at all.
No joint.
It is actually not referring to the larger thing. Not here, there is not even pleaded, I am in the family, that joint family is there. Actually, why I have read that lot, they are not going to party, genealogical table and all, why it is not correct because that is relevant for the family, joint family, whether it's a joint family or not. That is relevant, it assumes importance. Number one, the one who asserts has to prove that property is joint family property. However, person asserting proves that there was a nucleus which the joint family property would pay for, there will be no presumption of property being joint and ownership on us. So, why I am highlighting this judgment because trial court told that it's your burden to prove it. It's your burden to prove it. Indiscriminately, my lord, this has been stated. I will read the judgment. So kindly come to the next judgment, paragraph page number 10. I will read only paragraph 9 and not 13.
What is this, Amar? What is the proposition in law?
So kindly look at paragraph 9, paragraph 9. Whether courts will or justify holding that recital and mortgage insurance which is here 22 came into existence at an dispute point in time, do not establish partition between the members of Nalapa and Ravana, sons of Israel. But there is a document at a disputed point in time showing there is partition. Then now kindly come to paragraph 13. I am only harping on this particular sentence. It is well settled that presumption with regard to existence of joint family gets
Just a
weaker
moment.
and weaker from paragraph 13. From paragraph 13. The presumption is well settled that presumption with regard to existence of joint family gets weaker and weaker from descendant to descendant. That such weaker presumption can be reverted by reduction of nine evidence.
Para 17 you are reading?
13.
13, one please.
It is well settled.
Yes, yes.
Presumption regard the existence of joint family gets weaker and weaker from descendant to descendant, and such weaker presumption can be reverted by reduction of slight evidence of separate possession of properties, even the burden would to that family was not. But now here kindly, your lordship is aware of the genealogy, what your lordship refer to it,
They are the third generation.
third generation, and now it is much what is told there. Not
Before
only
the generation.
what
Oh,
if
specific.
this, we are talking about, even before my lord 1956 Act, the property was partitioned. Property was partitioned around 1954-55, even before the Hindu succession.
Yes, yes.
Lord, these are the only two judgments, Lord, I think with regard to joint family, property, book, and other things, Lord. To really,
Yes.
the, the other side of this Lord, whether joint family is good or property is good or not, whether oral partition is good. That is the second issue, which is interconnected.
Is that all are interconnected?
Yes. Lord.
So you have made your submission in regard to the joint family and also the oral partition.
Oral partition is one aspect I would
Okay.
Lord, if your lordship is holding, where to hold? That my lord, there is oral partition is told. Then my lord, I have no problem with regard to item number 1, 2, 6 to 8. Because it has fallen into.
Your share.
But-
To your share.
Yes.
It has already fallen
Yes,
to your.
but still 84-2. As per the oral partition, to which share?
Yes.
To
And
which
in
share?
light of your purchase, you have become the absolute owner of the property.
That is subsequent. My lord, the question is, what would happen to this? What would happen to this? The oral partition help you prove also. Lord, he has sold the property. 11/61. As per XB P6, which is a registered document.
Yes.
And Lord, I request your lordship to attention to section 3 of the transfer of property act.
Good section. Did you read? Okay.
Like, they are registered thereafter. Very comfortable after actionable claim. Lord, person is about knowledge, Lord. A person is said to be.
Yes. Yes. You read. You get the book. You what it? You can read the senior counsel.
Yes. If a person said to have notice of the fact, when he actually knows that fact, or when, but for willful abstention from an inquiry or such which he ought to have made or cross diligence, he have no need. But here, there is a change of 4 years old. The registered sale. You can look at it is after the not registered means then optionable claim, actionable claim, then my lord person, said to have notice of the registered
Yes.
registered deed. The person is said to have the notice of the registered deed. Of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry, or search which he ought to have made, or gross negligence, he would have known it.
According to you, the plaintiff was well aware about all this
Must
transaction.
be. Otherwise, he should say that, the plain. No, my lord, I have not produced my lord exhibit
She
C.
doesn't even say anything about the sale executed by her father in respect of item number
No,
2.
but see, producer that. Daily see that, my lord. I have not produced it. Exhibit P5 is not my document. Exhibit P6 is produced by her. What was her knowledge, my lord?
Yes.
Because, my lord, there will be limitation.
Yes.
You kindly take into my limitation.
Mm. Fifty-eight, 60. What is that you want to do?
58. Look, what I am saying, either there shall be a declaration. 58.
Yes. When the right to sue first occurs, according to you, she was aware about all this, and then
Whether
she.
she is aware or not, she should plead it. Not on that, whether I do not know whether she should plead it.
Yes.
Lord, 3 years is the limitation. Then, my lord, if she is seeking for cancellation, my lord, that is 59. Then if she is going to be minor, my lord,
60.
60B.
Ah.
Once again, when she attains majority, but I think, I do not know. Whether it's
No,
whether it's
no
not
plea
my-
about that.
No plea, it's not my task at all, whether it's minor or not. You tell you, this is where, my lord, when until it's 60, 58 will be applicable.
60A by the ward who has attained majority. The ward,
That is if she is minor.
if at all she contends that she's a.
61 B.
He is by the ward's legal representative. But who has filed the suit? She has filed the suit. So she is
60, I am saying about 60.
60A.
Lord, unless there is not either she should be, not whether the lordship was saying it's not whether. Here's a case where, my lord, all these documents are there. She is filing a vague suit, vexatious suit in the year much after that, 40 years of that, and saying, I'm entered partition, that's a partition, that's a property. Lord, whether this document binds up or not. If that is binds, my lord, that shall be declaration. Under 34 of procedural fact.
Yes.
If she says that, my lord, another aspect is that if there was a party, what capacity, my lord, he has sold the property? He is absolute owner. Whether by then, my lord, the property was open for partition, is it partible? Is it partible? I'm questioning myself, my lord. Whether the part, when he had, there was partition, he took the property and he sold it immediately.
Yes.
At that point in time, whether she was a minor or not, relevant at all. Whether property was open for partition.
Yes.
If that is not so, that's one aspect. Even otherwise, what I'm trying to submit, my lord, that this truth in this nature is not maintenance. They ought to have, my lord, 50, 34 or 35 of the Session Relief Act, taking a declaration along with my fact. So that suit is bad, my lord, order 2, rule 2.
Yes.
So, my lord, when I purchased property in the year 1967, on 3/7/67, my lord, as per Exhibit P5, I am the absolute owner of the property.
So your contention about self-acquisition also covers here.
Yes, that is why, my lord, we pleaded that it was self-acquired. So we have pleaded, my lord, and we have proved it. Not like
Yes.
do not, at this stage, it is relevant to see, my lord, whether that exhibit P6 is a sale or a market.
So that document is not in dispute. Rather, that document is not in dispute.
Litigation certificate, right?
No, but then they have not said that they should have been redeemed the mortgage. They redeemed the mortgage. They have not before the court seeking for redemption of mortgage. They are not even saying that it is a mortgage. They are saying there is a sale. But what is the capacity to sell the property also? That is also not forthcoming.
Not it is sale. But I will not take
Yes.
it is recital, not near recital. The document is interpreted. The last of any impact related to but
This is redemption. They have not even filed a redemption for mortgage. Yeah.
may I request the lord, glance at more to explain the
Yes.
10 line more. Not because the board holds that. It's relevant because my lord, board holds that it is the market rate.
They have not filed any suit against that mortgagor. Yeah.
So, that's what I'm trying to say. But now board holds that it's a market rate. So I am saying that it's not a market rate at all.
Okay. Okay.
Correct, my lord.
Which
First
line?
name, last line, 10 line.
From the page
Top,
number?
top, top. Actually, she from the top. From the bottom, my lord, the 8 line.
Ah.
ವರ್ಧೇನವರ ಮಗನಾದ ಮರಿಯಪ್ಪನಾದ ನಾನು
One second. Ah.
ಮರಿಯಪ್ಪನಾದ ನಾನು ಬರೆಸಿಕೊಟ್ಟ ಜಾಮೀನಿನ ಕಂಡೀಷನ್ ಪ್ರಕಾರ ಓನ್ಲಿ ಥಿಂಗ್ ಮೆನ್ಷನ್ ಏನೆಂದರೆ ಇದೇ ನೆಲಮಂಗಲ ತಾಲೂಕು ಹಾಸನಪುರ ಹೋಬಳಿಯ ಕಿಟ್ಟನಹಳ್ಳಿಯಲ್ಲಿ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆಯಲ್ಲಿದ್ದ ನನ್ನ ಹೆಸರಿನ ಖಾತೆಯಲ್ಲಿದ್ದ ನನ್ನ ಹೆಸರಿನ ಖಾತೆಯಲ್ಲಿದ್ದ ಇಟ್ ಈಸ್ ಓನ್ ಪ್ರಾಪರ್ಟಿ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿರುವ 84(2) ಕೋಡು ಜಾಮೀನು ತಕ್ಕುಬಂದಿ ಆಮೇಲೆ ಲಾಸ್ಟ್ ಲೈನ್ ರೂಪಾಯಿ 200 ಕಂಡೀಷನ್ ಕ್ರಯ ಮಾಡಿ ರೂಪಾಯಿ 200 ಫೈನಲ್ ಮಾಡಿ then this page after 4 lines ನಿಮ್ಮ ಇಷ್ಟಕ್ಕನುಸಾರ ನೀವು ಅದರಾಗಿ ಲಗಾಯಿತು ಇದಕ್ಕೆ 2 ವರ್ಷವಾಗಿದೆ 4 ಲೈನ್ 5 ಲೈನ್ 2 ವರ್ಷವಾಗಿದೆ ಗುರ್ತು ಮಾಡಿ ಕೊಂಡಿರುತ್ತೇನೆ ಈ ವಾಯಿದೆ ಒಳಗಡೆ ನಾನು ಈಗ ಹಾಲಿ ಮಾತ್ರ ಕಂಡೀಷನ್ ಕ್ಯಾರೆಕ್ಟರ್ ಮಾಡಿಸಿ 200 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿ ಮಾಡಿ ವಾಪಸ್ 2 ವರ್ಷಕ್ಕೆ ವಾಪಸ್ ತಗೊಳ್ತೀನಿ ಹಾಗೇನಾದರೂ ನಾನು ಅವಧಿ ಒಳಗಡೆ 2 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿ ವಿನಿಯೋಗ ಮಾಡದಿದ್ದಲ್ಲಿ ಪತ್ರ ಮೂಲಕ the indication is there. The indication is there, though it says condition driver, It is a document with a condition to repurchase. For which, my lord, I request your lordship attention to page section 59, C, TPI. C. 58C, my lord, sorry. 58C.
Mortgage by conditional sale.
The court holds that is conditional sale, mortgage by conditional sale. My argument is not so. It's condition of repurchase. Okay, to constitute, my lord, mortgage conditional sale, then look at the condition. These are the conditions must be there. On condition that on default of payment for the mortgage money, on certain date, sale shall become absolute. On condition that on such payment being made, it shall become void. On condition that on such payment being made, buyer shall transfer the property. Then one provided that no such contract shall be deemed to be a mortgage unless that these conditions are embodied in the document.
Now there is a condition that in the default of payment of the mortgage money on certain date, the sale shall become absolute. So that is a condition. This on the code.
That shall be a relationship of, my lord, creditor and vendor by a loan taker. Because mortgage means there shall be security. It's a security. Security code one. Security code mele relationship of creditor and, my lord, buyer, my lord, person who takes the loan. So, when I look at the judgment and writing, 2017-6.
Yes.
Four and five. Four, my lord. We have considered the submission. The question whether document is mortgage or conditional sale or sale is an option to repurchase is a very question determined in fact of the case. Paragraph 4, second note from judgment of question. There is a clear legal distinction between two concepts: a mortgage by conditional sale and a sale with conditional repurchase. The former is a mortgage, the relationship debtor and credit subsist. Debtor and credit subsist, and the right to redeem remains with the debtor. Yes. Where is this process? He says, I am the owner, take it. He is not saying that I am taking loan or whatever, I am selling it. The latter is an out and out sale, whereby the owner transfers all rights in the property to the purchaser, reserve personal right to purchase. But repurchase right is reserved, not 2 years condition is stipulated.
Yes.
Then, the question which category document belongs presents a real difficulty which can only be solved by ascertain intent of the parties on the consideration of contents of document and other relevant circumstances. Decide a case of any test. Trade ratio same proposition or then more kindly look at the next judgment, page number 5. Paragraph 13, from perusal. Paragraph page number 13, 8 page. The perusal of the aforesaid provisions, especially section 58C, it is evidently clear that for the purpose of bringing the manufacturer within the meaning of the market conditional sale, the first condition that market ostensibly sells mortgage property on the condition that such payment made buyer shall transfer property to seller. Although there is a presumption that transaction is mortgage by conditional sale in case where the whole transaction is in document, really because the terms are incorporated. In the same document, it cannot be always accepted that transaction agreed between parties as a mortgage transaction.
You would be in a you would be you would be in a better position if this is held to be a mortgage, because mortgage or conditional sale says if you don't repay the amount, it will become an absolute, and that gives a right to the purchaser.
I am settling the full of mortgage. I am not becoming a mortgage.
No, he
Normally,
becomes.
I am entitled for mortgage money. That is a big property should be adjusted. I have a burden to be adjusted towards this property. All that. It is going to help to be conditional sale, my lord. I am free of anything. There is no clause on my right at all.
So then, if it is a conditional sale, how does that vendor of yours get a right over the property?
I'll ask that and I'll come to
ಅಲ್ಲ
that.
conditional sale ಆದ್ರೆ then
Additional sale ಆದರೆ, Lord, what will happen?
then what is the right of that vendor of yours
Lord,
to
what
sell
happened?
the property?
Yes. In this case, what happened is he has purchased it. He has purchased it and saying that that is first deed or what is not
Ah.
the sale or mortgage. Lord, thereafter I redeemed it. Then our section 91, 82, 95 will be applicable. Secondly, subrogation. Other one. ಆಮೇಲೆ Lord, once again mortgage money, your redemption ಕೇಳಬೇಕು, all that things are there. I am safe in both ways. After finding out correctly. I am safe in both ways. If it is held to be a sale, I am free of anything else.
Correct. If it is sale, you would be in a better position. If there is a sale, because the mortgage says, assume it is a mortgage. Correct.
Still I am safe.
Because it will give a right to that vendor to sell the property. Otherwise, what is the right for the vendor to sell the property in your favor if it is not a mortgage? See, mortgage terms are in the event I don't pay that
That is why,
amount.
Lord, that's why if it is first one is held to be mortgage, second one is also mortgage.
No, that cannot be a sale. That could be a sale because he gets a right over that property in light of the mortgage being from absolute. The sale becomes absolute in his favor. He gets a right to sell the property. Otherwise, what is his right to sell the property? He has to keep it mortgage until it is redeemed.
Most important, here is a case where there is a stipulation of 2 years. What will happen after that?
So after 2 years, it has to be treated as an absolute in his favor, and then he gets a right to sell the property. In light of this conditional
That is
sale.
why, my Lord. Sale only. Both
Yes.
are sale only. Both are, that one or I will answer last.
Yes,
Because I do not want to go over.
Yes, now this court understood what is in the law. Yes.
Either way, my lord, I am saying.
Either by mortgage or by sale.
Yes. If your lordship were to hold that XBP by is P6 is a sale and later document is also a sale. If your lordship were to hold that it's a mortgage by conditional sale, I am saying with both. They will not get anything. At this stage, my lord, I am focusing on the sale because it will be confusing. That's why, my lord, when I am replying, that
see
question
what they
arises, I will answer. But now, last judgment, latest one, my lord, 2 days back. Paragraph page number 18, page number 14. Paragraph 18. How to be interpreted? Paragraph. It's paragraph 11, sorry. Paragraph 11. Not 18.
No.
The basic issue before the court is whether the entire so-called common parts.
No, you come to para 18 itself. Para 18.
Sorry. Is there.
Para 18. It is cardinal principle of
Cardinal principle expression that where the language therefore is clear and unambiguous. The common literal meaning ought to be assigned to the interpretation and one should not fall back on any other inference. Only the expression clear words portrayed in the instrument document must be considered and not surrounding circumstances. Not literal construction must be considered first rather than going into the intention behind it. That instrument gives the language of the instrument clear. And but here, what I am submitting, the lordship is asking little interpretation. Document is very, very clear. There is no ambiguity at all.
You have produced a typed copy of this exhibit P5. We have the typed copy of exhibit P5. We produced exhibit P5 and P6.
But here, I am giving up with this. Literally, my lord, the clear stipulations are there in the document. There is no scope for any kind of inference or not looking at the intention of the party. And then look at the contemporaneous conduct of the party. During 1967, what his father has done and what she has done now. Having sold the property categorically, unequivocally, my lord, in the year 1961. How much she is coming to the court. And then what
No, even if you say that it is a mortgage, the redemption of mortgage is by you. And if there is a partition, oral partition, then if a redemption is made by you, then it becomes your absolute property.
you can see who that there's a nucleus which
Correct, correct. That is how we have to.
that question doesn't arise more if you are holding this way.
But then we have to look into the document. That's why you get the typed copy.
This stage.
Yes, yes, yes.
But I will see
So we will stop here itself. We will hear them now.
whether there is any creditor and debtor relationship here at all in the document, then you can read it is not there. It's security. Whether it is any iota word showing that, my lord, the property is mortgaged for security. If that word is not there, my lord, is it just mortgage? Then, my lord, conditions are not fulfilled. So, what I am trying to submit, my lord, this page,
Yes,
with submission this, my lord,
yes.
property was orally partitioned, my lord, at a point in time, undisputed. That is from back, even before the Hindu settlement came into force. And my lord, pursuant to that, my lord, not only act of the parties, but also document. Act of the parties, my lord, therefore what we did, separately and independently dealt with the problem. And the public documents show that, my lord, they were act of the party. Not what is gone after that. Then, my lord, they have not even pleaded properly about the joint family property or existence of joint family at all. And the court below only relying upon exhibit B2 of the year 1996, which is an artist for the year regarding 97 part 27, but which is share my share, fell into my share. And I have produced the document, please to allow me I have put document. Soon after that, 67, 69, 74, 75, this also was located in the name of Chikana. That being the case, my lord, that exhibit P2, my lord, fell into the insignificance.
Yes.
So the entire, the only thing I have referred to is not read the judgments of the court.
Yes, we will leave that to him.
Yes.
Yes. Yes, you can just say what is your representations now. Paint is silent. Paint is silent as good as it can be. Yes, 2:30. ಅದು ಏನದು ಫೈಲ್ ತಗೋರಿ ಅವ್ರು. Joint memo, you have filed, huh? You have saved the court's time. Party is present, Nagaraj. Please mention the date. Date ಹಾಕೊಳ್ಳಿ. Copy ಕೊಡಿ. ತಗೊಳ್ಳು. Joint memo is filed by both the parties, duly signed by the petitioner. The joint memo reads as under. In terms of the joint memo, the writ petition stands disclosed on. And the court of the following order. Disclosure, and the petitioner to be reinstated into service with continuity of service without consequential benefits, without back wages from the date of dismissal. 18/12/2014 till the date of actual reinstatement. Further, the joint memo states that the service of the petitioner prior to the order of dismissal is protected and default cases pending as on the date of dismissal could be continued. The period of from 18/12/2014 till actual reinstatement is treated as not a continuous service under Section 2A of the ID Act, and the petitioner is not entitled to claim terminal benefits, including gratuity for the sick period. The parties have agreed to the joint memo, and the writ petition stands disposed of. When will you reinstate him? The respondent corporation to reinstate the petitioner within 4 weeks from today, from the date of release of this order. Yes. Yes. Nirmala madam, you should come to the court. Alva. I'll do next one. And this. Government advocate, Mr. Alva. We will take this matter after the completion of that argument. And Sampath Anand Shetty. Ready. We will take after that. Subramanya Bhatt. Disciplinary authority, you were not. Yes. Then what is service? This was some compensation. Then you have to say that it has been defunct. You have to file a memo to that effect. You didn't mention on the last occasion, right? So you file a memo to that effect. Yes. Madam, next matter. Which is that 1 hour. No power to interest the matter to the Lokayukta for. And no, what is this? 21 Nividirala. Even same, though. Ready. AV, this matter we have to dismiss, Alva. Lokayukta. ಇಲ್ಲ. We will hear that. No, it's a further hearing matter. So we either of it we have to do. Yes. 22. The petition has to be dismissed or allowed. You can't write. You can't refer the matter to the local. So then the entrustment to the Lokayukta. So this entrustment of the matter to the Lokayukta has to be set aside, right? And the disciplinary authority has to continue. From the Lokayukta. ಎರಡು ಕಡೆ ಬರ heard you ಆಯ್ತಲ್ಲ ಅದರಲ್ಲಿ ಅಷ್ಟೇ ಇನ್ನೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ if you have not well don't ask. We have heard you. It's only for we will dictate the order in the afternoon. Today afternoon. If time permits, we will go. Yes. Have you served the documents upon them? Your colleague was there on that day. If not served, kindly serve open. Yes.
Foot officer? Sir, 23 ಅರ್ಜೆಂಟ್ ಆಯ್ತಾ? 23. ಹಲೋ, 23.
ಏನಾಗಿಲ್ಲ ಸರ್ ಇದೆ.
ಇದೆಯಾ? ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಆರ್ಡರ್